Good afternoon, everyone. Welcome to our online seminar on upholding justice, exploring the Constitution and legal resources. I am Advocate Prathamesh Gaikwad, your host for today's session. Today, we have a thought provoking session planned where we'll delve into the intricate aspects of upholding justice through an exploration of our Constitution and various legal resources. We'll be discussing how these fundamental pillars serve as guiding lights in navigating the complexities of law and justice. But before we begin, I'd like to invite Shri Krishna Khairnar, volunteer of Dard Se Humdard Tak, to share a few words about the organization and its mission in promoting justice and legal awareness. Shri Krishna, over to you.
Hello, good afternoon, all of you. Today I'm going to giving some brief introduction about our organization. Darse Hamdartak organization is working to provide a free legal aid. The work of this organization is going on with the feeling that no one should be deprived of justice due to lack of money. Darse Hamdartak Samstha is working not only to release the prisoners from jail but also to get their relatives. We are working in various jails of Maharashtra like Mumbai Central Prison, Thane Jail, Taloja Jail, Bhaikala Jail, Pune Jail, and Kolhapur Jail. Till date, organization released almost 525 inmates from various prisons of Maharashtra. Also, through the organization, some of the prisoners have also got jobs so that they can get their hands working after getting their bail or after being released from their case. Thank you.
Thank you, Shri Krishna, for that insightful introduction. Now let's turn our attention to today's esteemed speaker. I'm delighted to welcome Mr. Maotoshi Ao, Assistant Professor, Delhi University, who will be guiding us through today's discussion. Before we dive in, I'd like to invite Advocate Praveen Bhoj to introduce our distinguished speaker. Praveen, over to you.
Good afternoon, all. To my fellow interns, colleagues, sir, and guest speaker. Welcome to yet another seminar from Humse Hamdard Trust. In today's session, we are going to learn a new insights from Dr. Maotoshi sir. Dr. Maotoshi sir teaches constitution law, administration law, company law, environmental law in Faculty of Law, Delhi University. Special provisions and sixth schedule to the Constitution of India, customary law, international IPR, and environmental law and governance are his subject area of research. Prior to this teaching assignment, he was associated with Singhania and Co. Company, Mumbai, during his legal practice in the High Court of Bombay. Over to Prathamesh Gaikwad. Thank you.
Thank you, Advocate Praveen, for that wonderful introduction. Now, without further ado, I invite Mr. Maotoshi to commence today's session on upholding justice through an exploration of our Constitution and legal resources. Sir, the stage is yours.
Okay, Namaskar. Am I audible, everyone?
Yes, sir.
Yeah,
Yes, sir.
thank you. Okay, before I went to my subject, I would like to extend my sincere gratitude to your organization for giving me this time. Even though I may not be able to speak to your content, however, I'll try my best to cover it in an academic way on the Constitution of India. My sincere and humble gratitude to your president, the host over here, the other members of your organizations, and all those people who have joined today to hear me, and also those people who have worked behind for this event. Thank you so much. I try to make a PPT so that it will be easier for everyone to understand. So let me share a PPT with you, if it is shareable. Yeah, I think it's now visible. Let me now just increase the screen. I will be going through the basic provisions of the Constitution of India in the beginning, and then, in fact, I prefer a discussion among us rather than me giving a lecture, which appears to be very boring. So it is always better that we have an exchange of information and correcting each other. Let me start with Keshavan Party's case on the definition of our constitution. So if you see Justice Shelat and Justice Grover's judgment on the definition of the Constitution of India, it simply says that it is an organic document and it must grow to take the stock of the vast socio-economic problems, to improve the sufferings or the vulnerable sections of the society. However, while improving the Constitution, we must also see that we develop the Constitution in consistent with the dignity and the unity of the nation. And therefore, we see that the Constitution of India is for the people. Now, one thing, if we study law in the context of political science, I will say it in a very negative term, that a law is a command, a law is a force, a law is a power. And therefore, it is imposed from the top upon the bottom. In other words, it is the force of the powerful over those who are not powerful. Now, the question is that if the definition of law is a force, or if it is a command which is forced by the superior upon the inferiors, does that justify law? Because to a layman, law is for justice. And therefore, when we talk about justice, everyone is equal, which we find it under the Constitution, especially under the fundamental provisions of the fundamental rights. And therefore, the question again arises, is the Constitution of India for the mighty people or for the inferior people? Now, the common understanding of our Constitution that it is equally applied to all. And therefore, when we understand that when Constitution is equally applied to all, irrespective of your caste, irrespective of your social positions, irrespective of your sex, gender, irrespective of the place from where you are or from where you are born. And therefore, we regard the Constitution as a noble document. And that is why Justice Grover and Justice Shelat has rightly said that it is an organic document. And therefore, the Constitution of India has evolved not from the top, but it is from the bottom. When I say it is from the bottom, it is made by the people. I think somebody has raised a hand. Any question? I don't mind interfering while I am speaking. Okay, I think it's by mistake. So our Constitution is from the bottom, and that is why we call it as people's constitution, unlike some other nations where there are constitutions which are made from the top and imposed on the bottom. And therefore, it is very correctly organized. Now, the issue of the development of the constitution or the growth of the constitution is the debate which we will see even in the future times to come. Because our constitution is a very flexible constitution. It adapts to all the social changes. In fact, I will say it applies to even the political changes of the nation. And that is the beauty of the Constitution of India. That it does not side one side, but it sides with all four corners of the nation so that it adjusts. And when I say all four corners, you will find different provisions under the Constitution, special provisions of the Constitution. Then we have the various schedules under the Constitution, etc. So that is what the flexibility of the Indian Constitution to maintain with the diverse needs, to maintain with the exigencies of both social, political, and other situations in the nation. And therefore, we say that the Constitution of India, unlike other constitutions of the world, it is an eternal constitution. It is an eternal constitution. It is an immortal constitution. I mean, it's an immortal constitution. In other words, a constitution which is never going to die, or say like a constitution which will never be rejected by the society because it will adapt with the changes in the society. Coming to the question of consistency with the dignity and unity of the nation, and that is very clearly found under the provisions right from Article 1 till the fundamental rights, the director principles of state policy, the judiciary, the center-state relationship, and even the then schedule to the Constitution of India. And that is where you find that it always attacks to the dignity of the individual citizens while maintaining the unity and security of the nation. So that is what I find it, the Constitution of India, the most beautiful and the most visualized, designed constitutions of the world. And a beautiful constitution and an eternal or an immortal constitution that will survive at any cost or to any political, social, or economic situations of the nation. And that is what we owe to the framers of the Constitution of India, especially people like Babasaheb Ambedkar. Now, let's come to the second slide here. Now, the nature of the Constitution of India and the basic structure theory. I will not go into much of the theories. I will just stick with the basic structure theory because that is one of the most important theories of the Constitution of India. Now, there are some landmark academic judgments which are not very recent, very old landmark judgments, but I have taken these judgments because these are the pioneer judgments in the history of the Indian Constitution. Like the Kesavanand Party's case, the West Bengal's case, Bomai's case, and Ramjawa Kapoor's case. Kesavananda Party's case, let me come first here. And if we look into the Kesavanand Party's case, we see the evolution from the judiciary, the basic structure doctrine, laying down that this basic structure doctrine cannot be destroyed by the parliament or through a parliamentary amendment. But the question still remains that can all the provisions of the Constitution or does the Parliament has the supremacy over the Constitution? Or is it the judiciary more superior than the Parliament? Because we live in a democratic nation and the will of the people is supreme. And therefore, judicial pronouncements, which are from a few judges, without taking the opinion of the masses, based on some certain laws, maybe already decided judgment in India, or we may have taken the instance of some other democratic nations of the world and given the judgment. So the question remains parliamentary supremacy on the legislative supremacy. Now, if we go back to Keshavanand Party's judgment, it is very clear, and all the law students are aware about the basic structure doctrine, and you cannot touch on the basic structure doctrine by any parliamentary amendments. Now, but a question that arises in the contemporary days is, if the parliament wants to make some modifications under the fundamental rights, to what extent it will be allowed? Because in our constitution, we do not find any express provisions that prohibits or that tethers the parliament from amending the basic structure doctrine, because unlike the German constitution, we do not have a basic structure doctrine laid under the Constitution of India expressly. As for example, if we go into the German constitution, the first part of the constitution is the basic structure, they call it, and that lays down with the rights of the citizens, etc. And after that, there is a provision under, I think it's, if I'm not wrong, if I recollect correctly, I think it's Section 79 of the German Constitution, which says that the basic structure doctrine cannot be amended. That is what expressly given under the German Constitution. Now, we may say that even the advocates of the Keshavanand Party's case may have taken the inspiration from the German Constitution. Obviously, we are not very sure, but during the time, the German Constitution was already in existence, and that is what there is only a single constitution of the world in Germany where they talk about the basic structure. And therefore, the question is that, can the Parliament of India today insert a provision under a constitution like the German constitution that the basic structure doctrine cannot be amended or cannot be touched by a parliamentary amendment? Right? So that is where the question of Keshavanand Party's case still remains on the willingness or on the will of the Parliament of India to have it structured under the Constitution of India expressly. The question then remains that what will be the consequence if such an amendment or such insertion is made in the Constitution of India, basing on the basic structure doctrine laid down by in Keshavanand Party's case, and borrowing or taking inspiration from a constitution like the Germany. Will it maintain the security of the nation? Will it maintain the unity of the nation? Will it protect 100% the fundamental rights of the citizen, irrespective of any status, irrespective of the place from where he lives? That remains the question which scholars debate, or the scholars visualize, which may happen or which may not happen. Now, the separation of power under the Constitution of India, though we do not find it expressly given under the Constitution. But if we read through the provisions of the Constitution, it clearly says that there is a separate function defined under the Constitution for the three organs of the state. And therefore, in the administrative system of the nation, is it necessary that the judiciary should be completely kept independent from the other two organs of the state? Or the executive of the nation should be kept completely independent from the other two organs of the state, etc.? Now we see some recent judgments like on the independence of judiciary, which talks a lot on the separation of power, that judiciary should be kept completely independent, even in the case of appointment or transfer of judges, etc., from the executive or the political interference. Now, in Ramjawa Kapoor's case, it is laid down that the relationship between the executive and the legislature is like the British cabinet system, like a hyphen that connects the buckle. And therefore, we see in India today that even the judiciary has, though, protected its independence from the executive and the legislature, but we find that the judiciary in India has not to a very strong extent protected the executive from legislative interference. Now, if we give a strict separation of power between the executive and the legislature, will it help in the smooth administration of the nation? Now, if we give the legislature, our MLAs, our MPs, etc., within its limited function of attending the parliamentary sessions and making legislation, and not interferences in the executive department of the state. In other words, it means that there will be no ministers in the state, cabinet ministers in the state or in the union government. Will that help in running the nation? Right? So that appears to be typically impossible, because the legislature and the executive, if we follow the British system, the British cabinet system, then they work together. And therefore, in the administration of the nation, the question is that, do we still require to follow the colonial system, or we need to evolve a different administration which might have been prevalent during the rules of the Chanakyas, the Guptas, the Marathas, etc.? That administration of the kings, like the Maratha kingdoms, the Chanakyas, the Cholas, etc., that system of administration, will it still suit the nation? Because the nation is adapted to the colonial system of administration. And therefore, the question still remains, even though the judiciary is independent, what is the opinion, the political opinion or the political will on the separation of power between the legislature and the executive, and what will be the judicial view in the future? That is what the scholars have to study, and that is what people have to understand and make some changes in the administrative system, so that we do not find the loopholes of the relationship between the executive and the legislature in administration of the nation. Now, coming to the center-state relations. Now, one classic case, landmark judgment, long time back, 1963 judgment, where no one of us were born, the relationship between center and the state in both economic, legislative, and administrative relationship. Now, in India, when we adopt our constitution, we have taken neither exactly a federal system like the United States, but we have inspired by the federal system that was prevalent in other parts of the world. And therefore, even though we have a federal system in India, but we find that it is more of a unitary system of governments with the center rather than a purely federal in character. And the division of the powers under the seventh schedule to the Constitution of India, that is the list 1, list 2, and list 3, etc., especially the list 1 and list 2 is totally borrowed or taken from the Government of India Act 1935, which was in fact a colonial enactment. Now, center-state relationship when it comes, what I mean here is that do we still need to follow those colonial enactments of the center-state relationship, list 1 and list 2? When we say in Article 1 of the Constitution that India is a unit, or in other words, even if we see the structure of the Constitution, it is of a unitary government rather than a federal. But now today, the problem is that we find that there are so many provisions under the Constitution giving autonomies to various states in their own affairs. There are various provisions for the management of the nation according to various sections of or various regions of the nation. And therefore, when we see the actual working of the Constitution, it appears more to be a federal rather than unitary. The unitary thing comes, the unitary element comes only when it is with the nation as a whole. Now, in other words, what I mean to say is that has the Constitution divided the nation? Now, the meaning of a constitution is to bring all the people together under a single umbrella, right? All the states. And that's why all over the regions of India, we have a single constitution. We do not have a constitution of Maharashtra or UP. And therefore, the meaning of constitution is to bring the people together under a single umbrella, under a single law. But when we go into the domestic affairs of a state, we find that each state has its own laws. The only uniform law is the procedural laws, the criminal laws, etc. In other words, the municipal laws. And therefore, with such diversities of laws in India, giving an autonomy to the legislature of a state, right, then it appears to be a totally federal in character. But the object of the Constitution of India is to have one uniform law, right? One important provision under the Constitution on this uniform law is the Uniform Civil Codes. And on the implementation of a uniform civil code, the objective of the nation coming under a single law, even in the cases of personal and domestic laws, is the question we have to decide that what would be the consequence if such a law is made. Will it bring the nation under a very strong, united, one nation, one law? That's something which we have to discuss and we have to implement on it. Now, that is where the center-state relationship on the legislative part, a contemporary concern I'm sharing with. On the economic factor, the center-state economic factor, states like the Gujarat, states like Karnataka, states like Maharashtra are industrialized states, and from historical point of view, even if you go to a historical point of view, these states are very rich states with a lot of resources. I don't mean to offend anyone, but I personally think that they are very rich states, even though there may be to some extent degree of poverty. But when we look at the exchequer of those states and the infrastructural development that they have built till today, they are the developed states and the most influential states of India. But there are some certain states somewhere in the northeastern part of India or on the eastern central part of India where the states are not that influential or rich in resources as those on the western part of India. And therefore, the question is that sharing of resources, right? So these states which are not influential or which do not have a sufficient amount of resources cannot generate revenue or cannot provide livelihood to its citizens. And therefore, the assistance of the other states having more resources are required. And therefore, the people of those influential states may have an objection. Why our resources are being shared without any revenue? Right? As for example, Bombay contributes one of the toppest revenue to the nation, but Bombay doesn't get back that amount of revenue that they generate into the development of the city or the welfare activities of the people living in Mumbai. Similarly is with Maharashtra, right? They may be contributing a lot to the nation, but you do not get the sufficient amount of development, etc., from the central government when it compared to the contributions. And in fact, some states in the northeastern states, etc., go more funding is being given to these states despite they generate very less revenue or they contribute very less revenue to the nation's exchequer. And therefore, the sharing of economic resources is a concern when it comes to center-state relationship. Now, that was also debated at the Constitution, at the framing of the Constitution, at the Constituent Assembly thoroughly. There were objections on equal distribution of resources by the center, right? But the conclusion was that there should be economic coordination among the states. If you want to maintain unity, if you want to maintain the integrity of the nation as one nation, then we need to help each the brother states or the sister states to bring your brother state who is not well enough to provide him so that there is equality or equal distribution of wealth in the nation. And that is what even the government till today has been following that one. And therefore, the sender has been given the power to override any laws made by the state if it is against the unity or integrity of the nation or against the economic coordination of the nation. And that is what the state of West Bengal, in the state of West Bengal's case, is clearly laid down, that the mineral resources like the coal does not belong to the state of West Bengal. It belongs to the nation, right? And therefore, the state of West Bengal cannot make a separate law. And if that law infringes or trenches upon the central law, the law made by the state will be invalid. And that's how the law made by the legislature of West Bengal was struck down by the Supreme Court. Obviously, they can make a law on the domestic level under list 2 of the Constitution, of the 7th schedule of the Constitution, but they cannot trench upon the central elements. And that's what the center state. Another important case is the Omais case, which every one of you must be aware, right? Followed by But why am I taking only Bomai's case? Because this is one of the first landmark judgment where the Supreme Court started the process of judicial review in the proclamation of emergency. Now, an important question arises by looking into the judgments right from the Bomai's case till yesterday's judgment. The power of the central government for declaration of an emergency in the state. In other words, which we call it as the state emergency. Is that necessary in India? The first question. Should we amend the provisions under the Constitution on emergency to suit the process of maintaining integrity and security of the nation? But these are the two important questions that arises when we always talks about the emergency provisions of the state. Now, we have seen in history that emergency provisions can also be used to the advantage of certain political parties who may be in power. And therefore, the question is that today, are we required to change the emergency provisions, or do we need some certain amendments? Because during an emergency in a state, right, the will of the particular people living in that state may be suppressed because of the question that we have a federal structure. And in a federal structure, the will of the sender can be imposed only when there is a constitutional breakdown. Now, the question is that if a political party is unable to attain majority in a state, can the governor, without giving an opportunity to the largest party, go ahead and request for an emergency proclamation? Now, certain provisions in the special provisions with regard to the Northeastern state like 371A, C, H, etc., you will find that the governors in those states have been given special powers. Special powers in the means that their powers are unlike the governors of other states. And therefore, in case of these states, the governor, if he exercises his power as per the constitutional provisions, he may have the power to go ahead, unlike the other states. Now, can such a provisions or a more simplified or a modified provisions like those special provisions under the northern states when it comes to the powers of the governor, can it be inserted under the Constitution of India? Right? Because ultimately the object of India, of the nation, is a united government, is the unity and the integrity of India. And therefore, the power of the sender should be strong enough. Right? Now, let me take an example, an illustration. Obviously, it may not be very consonant with what the topic we are talking. In India, in our individual families, we mostly follow our family customs and traditions. When you have to get married, it is, in most of the cases, decided by your parents. Right? In most of the cases, in other words, if you want to get married, the permission is always sought from your parents. You cannot just go ahead and get married without even informing your parents. That is totally out of the question of the traditions and customs that we have in India. So even though you are a citizen of India, the Constitution of India applies to you, but when it comes to your customs and traditions, your parents' opinion is supreme. In other words, Constitution has given the liberty to get married, to not get married, to do whatever you like. But still, you take the permission of your parents to get married. Even if you like someone and if you want to get married, if your parents say no, you cannot exercise your fundamental rights. Just because it is our tradition and customs to respect your parents or to be humble and obedient to your parents. Now, similarly, in that instance, when it comes to the center-state relationship, in the case of the executive or the administrative relationship, is it possible? And if we insert a provision under the Constitution of India, giving the ultimate power to the center to decide when to declare an emergency in a state. Now, judicial judicial view would be very different. But here, what I'm talking is in a political sense or in a political way. Because administration of a nation is not by the judiciary. Administration of a nation is by the legislators and the executive. And therefore, the will of those executive and the legislature should also be taken into consideration to some extent and not always decide on some certain judicial pronouncements laid down either in the United States or either in the United Kingdom. Right? The Constitution, therefore, should also be construed in such a way that we follow in our customs and traditions, even in the center and state relationship. And that is what something we need to review, we need to judge and decide on it. Right? So that we have a more stronger and integrated nation by or with the help of the force of the Constitution and the law. All right? I think I'm taking a lot of time. I'll try to wind up as early as possible. I think I will. Now, the next question is on the question of to set the territory of India or to admit a new state or a new territory in India and the creation or extinction of a state in or within the territory of India. One such case, the first case which here, you can find it here, these are all landmark judgments, long time decided. Everybody Union case, Sukumar's case, R.C. Botwell's case, etc. Now, when it comes to addition of a new territory into the nation or to give away a certain territory of ours to some other states, do we require a constitutional amendment? And if we do not do a constitutional amendment on it, can it be done just by the executive? That question has been discussed since these judgments. And obviously, the Supreme Court has been of the view that obviously just a political agreement won't be sufficient. We need to do something with the legislative part also. Now, the question of sovereign arises here. In India, the sovereignty lies with whom? Right? The sovereignty lies with whom? Is it with the executive? Is it with the legislature? Or is it with the people of the nation as a whole? Right? And therefore, when we decide whether to add some territory or whether to give out some territory, I think a political will alone is not sufficient, or an executive will alone is not sufficient, etc. it should be the consensus of all the citizens of the nation, because the nation belongs to the citizens. And therefore, such kind of decision, irrespective of the judicial pronouncement, but without prejudice to the judicial pronouncement, I would say that the mass or the opinion of the mass is also important before taking any decisions on it. But till today, we have only seen, along with the judgments of the court, that the executive decides and then a constitutional amendment is done. Obviously, we may agree that the legislature is the representative of the people, and therefore we accept to what the legislature says. But there are some certain issues where it should be debated. There are some certain issues where opinion of every citizen should be taken, or an opportunity of all the citizens should also be taken before deciding on the issues of the territory of India. The creation or bifurcation of a state into one state, from one state to two states, three states, or the changing of name, etc., are done by a simple majority of the parliament, and therefore we do not require much debate on it, because ultimately the center is the supreme, and it is the center that should take the decision of whether a state can be bifurcated into two or more states, etc. And I don't think so we need any kind of further arguments or further debate on those powers of the parliament. And I personally feel that doesn't require any kind of amendments. Now, on the relationship of the president or the governors of the state with the council of ministers, you have seen some landmark judgments which you all are aware: the Indira Gandhi's judgment, H.T. Deve Gowda's judgments, the Shamsher Singh judgments, and the MB Special Police Establishment's case judgments. Now, when it comes to the election or the selection of the prime minister or the chief minister of a state from among those persons who are not member of the parliament or of the state legislatures, the constitution says 6 months. And after 6 months, if he does not get elected, then he has to quit. Now, if the party in power wants that person, even though he may not be elected, to continue as a council of minister or as the prime minister, etc., the constitution at present totally prohibits. Now, the question is that, can we amend those provisions of the constitution? Right? Can we amend those provisions of the constitution, removing the word 6 months? So we need to discuss on the judicial interpretation in case of an amendment under those provisions if those 6 months is removed. Right? The judiciary itself has said that these provisions are valid provisions because it is an exception to the principles of democracy. But if you could not get elected within the 6 months' time, you cannot become a member, a council of minister, or a prime minister or a chief minister, because if you do so, it will be a fraud on the constitution. That is the judgment till today. Now, if the Parliament of India removes those 6 months, what will be the judicial interpretation? That is the question. What will be the judicial interpretation? Because the question is that a basic structure of the constitution? And if we remove the 6 months time, will that go against the principles of democracy? And another question is that, will that be within the parliament's power to amend? Because the judgment of the Supreme Court is that the parliament also does not have the overall supremacy to amend the constitution. They can amend certain provisions of the constitution, but they cannot amend all the provisions of the constitution. They have to retain the basic structure. And therefore the question is that if we remove those 6 months, will it not violate the theory of the basic structure? Is it within the amending powers of the constitution? And what would be the political and social consequence is another one debate which we need to focus in the coming years in the development of the Constitution of India. All right. Now, Samsher Singh's case and the MB police establishment case also give us some ideas on the powers of the governor of a state. Right? The Constitution says that for example, the highest the post holders, the governmental post or the executive post holders are appointed by the governor. But actually the governor does not play any role. It is the state. For example, the state civil service officers, the state judicial officers, etc., are appointed in the name of the governor, but the governor does not play any role. It is the state who decides. And therefore, even when you file a case, you cannot sue the governor of the state. And therefore, the question still remains that on the discretionary power of the governor, right? We have some judicial interpretations, not only some sessions case, there are a lot of judicial interpretations still today. But one question which we need to still focus is the question of the discretionary power of the governor in appointment matters. What is the power and what power should be given? And therefore, whether we require some constitutional amendment on those powers of the governor, right? As for example, if we see the Delhi State Act, the lieutenant governor has some certain powers which the chief minister doesn't have, and therefore the chief minister cannot play much role. So can we have the kind of provisions under the under the Constitution of India regarding the powers of the governors of the state? Or should we give the governor only as a rubber stamp? This again needs a lot of political debates and also the political will of a particular state. And if the center makes an amendment on that, will the states agree? Right? Will the states agree? That's the question. And therefore, why am I saying so? This is because why the governor should only be an agent of the center in the state? Right? Why the governor should only be an agent who is a rubber stamp in the state? Yes, we agree that the government in the state is elected, or it's the will of the people, right? But when it comes to the implementation of the Constitution, on the question of integrity of the nation, on the question of maintaining the constitutional norms of India upon one of its federating units, obviously the Constitution of India will prevail. And therefore, the question is why the governor should remain only merely a rubber stamp, right? So that's what we need to focus, right? And another one case which we say is the MB Special Police Establishment. It's on the power of the Lokayukta, right? And the power of the governors, right? Now, question, therefore, this case help us to understand the challenge that I have just spoke. So, can the governor, therefore, prosecute the chief minister? That's the question. Can the governor prosecute the chief minister? Or does the governor have the power to issue a warrant of prosecution to the chief minister? Right? So MP police establishment clearly says yes. When there is no such law written on the constitution, but when it comes to the prosecution, then the governor has to do it. Right? And that's how the judiciary has interpreted the powers of the governor on its discretionary power, which we can take inspiration in improving or in further development of the Constitution of India. Now, another one important topic is on the parliament and the state legislature, the legislative privileges. Right? So you'll find here some few judgments, B.R. Kapoor's case, Lily Thomas' case, Raja Rambal's case, etc. These are all leading judgments, not only in academic, but still we use these judgments very strongly. So when it comes to parliamentary privileges, and when I talk on parliamentary privileges, we have to talk a little bit on the Representation of People's Act as well. So the question remains that what power does the Legislative Assembly of a state or the parliament has in expulsion, right? In expulsion of a member of the legislature, right? Or in case if someone is convicted by the lower court and appeal is pending before the appellate court, can they contest election? Right? First question, P.R. Kapoor's is Jayalalitha's case that you have already seen, and mostly a big news during the time. And another question, as I've said, is that does the parliament has the power to of expulsion, right? Because the member of a parliament is elected by the people, and the normal general rule is that whoever appoints you, only that authority can suspend you, and no other authority. So an MP or an MLA is elected by the people, and therefore he can be called back only by the people. And therefore the question is not whether he can be removed, whether he can be suspended by the legislature. Right? Well, that has been clearly discussed in Raja Rambal's case, and the other issue has been clearly discussed in the B.R. Kapoor's case and the Lily Thomas case. But irrespective of those judgments, again, the question is that, do we need some development in the Constitution? Are we required to put some certain amendments in the Constitution so that, the Constitution expressly says about those provisions, and therefore there will be no scope of judicial interference, because these are all judicial interpretations. And therefore, what I mean to say is that, is it necessary that we should make some constitutional developments so that there is minimum judicial interference? Right? So that is one important. Ordinance, obviously, you can say what was case in the Krishna Kumar Singh's case, which are landmark judgments, which lays down that the governor cannot misuse the provisions of ordinance under the Constitution by re-promulgating the same ordinance again and again. And that will amount to a fraud on the Constitution of India. Right? But there is no express provision under the Constitution which prohibits the governor from re-promulgating an ordinance again and again. It is only a judicial interpretation which says that you cannot repeat the same ordinance again and again. right? Now, tomorrow, the parliament make an amendment that the governor, when the parliament is, or when the legislature is not in session, can re-promulgate an ordinance whatever he thinks fit and fine. Will that go against the norms of the constitution? Will that go against the judgment laid down in what was case in the Krishnan Kumar's case? And so what will be the opinion of the judiciary in case if that is challenged? Right? Because sometimes there may be some necessity that ordinance may be promulgated by the governor, but the legislature may not have taken it and it must have lapsed. And the next time he can revoke it because that's an important provision to be applied in the states. The state government may not be willing to apply it for the best reasons known to them, but for the central government, it is important, and therefore that law should come into force in that state. Yeah? Obviously, there are other ways that the center can do it under the list 1 of the constitution. But if there are some certain situations where it has to be passed only by the state, and the state is not willing to pass that law, then we require some certain constitutional powers to be given to the governors of the state. And if tomorrow we make some changes in the constitution, will it go against these judgments of the Supreme Court? And if somebody challenges it, what will be the opinion of the judiciary? That's where we need to focus. A judicial review, right? Judiciary and the judicial review is a topic which we can discuss for days and days. It is a never-ending topic. It is such a vast topic. But I will just take a couple of cases from where we can get some inspirations. Right? The special reference number 1, I think that is the 3rd judge's case. Then the NJAC judgment, that is Supreme Court Advocates on Records case, that is the 4th judge's case. And finally, the Roger Matthews judgments. Now, in the Roger Matthews judgment, the court has laid down in banner number 88. You can see it in the screen, and it clearly says that the judicial review is intended to ensure that every constitutional authority keeps within the bounds of its constitutional functions and authority. Right? In holding a constitutional institution within its bounds, judicial review does not trench upon the doctrine of separation of power. Right? That is what the court has said. Now the question remains is that when the judiciary gives a decision saying that it has not trenched, the judicial review has not trenched upon the doctrine of separation of power in India, has it practically not trenched upon the constitution or upon the separation of power? Yes, it is agreed. But judicial review is the bulwark of the Indian democracy. When it comes to individual fundamental right, when it comes to my individual right, when it comes to individual right, judicial review is the soul of the Constitution of India. Without the power of judicial review, the fundamental rights of the Constitution of India cannot be enforced. Right? Because the executive are not the same in all the places. A executive may be liberal, B executive may not be that, and therefore, in the process, your fundamental right may be infringed. And therefore, judicial review is the soul of the fundamental rights, for the protection of the fundamental rights. But when it comes to the legislative and executive affairs of the nation, legislative and executive affairs of the nation, we need to, again, think a little more on the relationship that the judiciary shares with the executive and the legislature in the form of judicial pronouncements. The judicial pronouncements, obviously, they say that the doctrine of separation of power has not been trenched upon. But the question is, practically, has it trenched upon or not? right? So therefore, if we go back into those judicial appointments and judicial transfers cases, the Supreme Court has always maintained that there is a separation of power between the legislature, executive, and the judiciary, and therefore the opinion of the Chief Justice of India when it comes to appointment and transfer of justice is supreme. Is supreme. Yeah, we agree to that once. We need to protect the independence of the judiciary in India for the sake of the citizens. Right? But does it hinders, the question remains, does it hinders in the governance of the country, in the administration of the country? Right? That where we need to research more, where we need to focus more, right? We should, in other words, have a system where certain political, legislative, or you can say the executive power are kept from judicial interference. Because the moment the judicial interference comes, the development of the nation halts. You may be doing some work here, you may be doing some work here, right? And somebody challenges that one, the court issues some interim orders, and then the work is halted, and that goes on for days and days and months. Now, but that is also required because that power of the Supreme Court or the high courts cannot be taken away. If you take away the power, then you are interfering in the basic structure doctrine of the country. You are interfering in the independence of judiciary of the nation, and therefore you are violating the constitutional provisions. Therefore, the judicial review, the independence of the judiciary is must to have a progressive nation. But there are certain elements in the society which will come in the way of development of the nation by misusing the power of judicial review. And therefore, we need to have a vigilant watch on the misuse of those powers of the court by certain elements. And that is what very important, which we, if required, we need to make some law, or otherwise the public and the judiciary should be more vigilant so that the process of development of the state is not hindered. Right? Now, amendment part. Right? I am not touching on the fundamental rights today. I'm not touching on the emergency part today in detail. So, amendment. Right? Now, let me just say here, if you say the Indira Gandhi versus the Rajnarayan's case, right? It says, no part of a fundamental right can claim immunity from a mandatory process by being described as the essence or core of that right. The power of amendment would also include within itself the power to add, alter, or repeal various articles. That is para number 251 of the Rajnarayan's judgment. Then Waman Rao's judgment, right? It says in para number 15, we would like to add that every case in which the protection of a fundamental right is withdrawn will not necessarily result in damaging or destroying the basic structure of the Constitution. The question as to whether basic structure is damaged or destroyed in any given case would depend upon which particular part of the Part 3 is an issue and whether what is withdrawn is essential to the basic structure of the Constitution. Now, if you see these two judgments, the court and these judgments comes under the Keshavanand party's case. Now, the basic structure doctrine, even there is a judicial, a little varied judicial opinion from the Keshavanand party's case. And that shows us the judicial, reviews of its own decision, right? Judicial review of judicial decision. So we may say that this is the basic structure doctrine, and here you should not touch, you should not do anything. But the basic structure doctrine in Kesavanand Party's case was tested only on the question of the right to property, and it was not tested on the rest of the provisions of the Constitution, or we can say the Part 3 of the Constitution. It was only on a single issue, that is the right to property. Right? And therefore, the basic structure doctrine, even though still it's valid, right? The judiciary also has a varied opinion on it, except the separation of powers. In some other issues, the judiciary have varied opinion, and that opinion is dependent on the circumstances or the exigency of the case, keeping in mind the overall development of the nation, keeping in mind the social fabric of the nation, the social condition of the nation, the political conditions of the nation, and also the unity and the integrity of the nation. And therefore, now we say, can safely conclude that the basic structure doctrine is not what we assume, right? It depends on cases to cases, and there is sufficient judicial pronouncements which shows that the basic structure doctrine varied according to the different or varied exigencies of the nation or the society. Okay, now I think the time is almost going over. So let me just conclude our today's discussion, and after that I will be willing to take questions, or we can have an interactive session if we still have time. Now this is an art of the recent judgments, and that we convey our gratitude to the judicial system and the apex court in India. For it is one such constitutional machinery that has protected the Constitution for such long years and upheld the individual dignity and the supremacy of the Constitution. So if you come into, I have given here some 2-3 cases which we need to ponder, or which we need to keep in mind after we have our classroom discussion, so that you can also analyze, or you can also think of what course of action is required in the future times to come. One recent judgment is Bomba Perry versus the Union of India, and I have given you here is on the sedition law in India, right? The sedition law in India. And now with the BNS, there is no more sedition in India. That law has been removed. Now it is only the question of the sovereignty. But there are other cases where such cases are pending in the court. And therefore here, the Supreme Court has kept the matter for future considerations. But there are certain paragraphs in this judgment where the Supreme Court has said, right, that the constitutional validity of 124A, right, is something which we need to discuss, even though the new legislation will come into force, but you cannot have a retrospective operation of those laws, of the new law on the old law, right? And therefore the court says, even if the law which is proposed to be placed by the government before the legislature results in modification of the existing provisions of section 124A, there is a presumption that a penal statute would have prospective and not retrospective effect. existing prosecutions under 124A will likely be governed by that provisions. So that is what the Supreme Court has said. And therefore, we need to discuss that whether the legislature should come up with such a law that the previous or the existing prosecutions or the pending cases under 124A should be done away by giving a retrospective operation of the new BNS. Right? That is where it's purely political and public opinion. It depends purely on political and public opinion. Right? But this is one important judgment which still we need to think before the judiciary gives a judgment, so that we need to have a political will or the will of the people. Now, another one issue is on the cooperative federalism, Mohit Minerals case. Now here in Supreme Court has here laid down that the GST Council's advisors, etc., are not binding on the union and the states. Now we have a GST Act that constitutes the GST Council, and the objective of the GST is to have a corporate or a cooperative federalism in India. But the Supreme Court says on certain grounds, which are given in the I will not discuss it, you can read the judgments, say that GST is on certain reasons, GST Councils is not binding on the union and the states. Right? Now that is a very landmark judgment. Why am I saying it's a very important judgment, which we have to keep in mind to discuss further, and whether you will require some constitutional amendment or not, is because the GST was issued with the objective of a single taxation in the nation, so that there is no complication of taxation, right? And that is what the cooperative federalism is, right? Only one tax you will impose, and the taxes will be shared among the center and the states, etc., to be very simple, right? But now the GST Council has been therefore made to make laws, to make policies, etc., and to see that the law made by the legislature has been is carried to that extent, so that the objective laid down under the constitutional amendment on the taxes is achieved. Right? And therefore, the power of the council, GST Council, to some extent appears to be nullified. Right? For the reason that the GST Council is not the will of the people to be imposed upon the union and the states. The state government may decide something which the GST Council may not agree, or the GST Council may advise something which the states may not agree. And the states will always maintain that we are the representative of the people, we are the will of the people, etc. We are the voice of the people. Who are you? You are just a parliamentary created machinery. You are not the creation of the original constitution. You are not the creation of the original constitution. You are just a parliament created authority that may remain today, and tomorrow you may not remain, because if the parliament decides to do away with the GST, then this council will go away. Right? And therefore here the Supreme Court has given a very simple judgment that it is not binding upon the states and the union. Right? So in the cases of these taxes, we still have to see that what law would be best, so that there is no contradictions or there is no conflict when it comes to taxation in India. Right? And that's something which we still need to discuss. Then the Chief Election Commissioner of India versus the Vijay Pashkar. Now, it is on a very important issue, because we live in an era where everything can be made public because now everything is online, right? And therefore, the question of the remarks or the opinion of the court made in oral, which are not recorded in paper, whether that can be made open to the public or not, right? So that was considered, and it is such an important, a beautiful judgment, which the court says that these informations, like it may be a remark of a judge, it may be the remark of the court, which may not have been recorded in the judgment, etc., can also be made public, and it does not hamper anybody's rights, right? And therefore, the court has defined on what is an open court, and the court says the concept of an open court requires that information relating to a court proceeding must be available in the public domain, and the citizens have a right to know what happened or what transpires in the course of a judicial proceedings. Right? So that is one such a very important judgment, a landmark judgment of the Supreme Court. And finally, the Vinod Dua's case and Anuradha's Passion's case. Now, this is on our fundamental rights, another one important judgment where the Supreme Court has upheld the fundamental right of the citizens by saying that a citizen has a right to criticize or to comment on the measures undertaken by the government and its functionaries, provided that it does not lead to violence or go against the established law of the nation and by creating a public disorder, right? So, but here, why am I focusing on this judgment is because you have a right to voice, you have a right to criticize, you have a right to comment, but if that brings disorder, but if that leads to the disorder of the established law of the nation, then there can be penal prosecution against you, and that is what the importance of this judgment is. And finally, on the fundamental rights aspect, Anuradha's judgment again, the court has given a very clear judgment on the right of internet as a fundamental right. Right now, the court has said that here in this judgment, right of internet is a fundamental right, and therefore the authorities cannot suspend your internet for a long time. It can be temporarily suspended, providing proper reasons why then it is suspended, and also should be made available or should be made notified that for how many hours, for how many days the internet will remain suspended. They cannot do it permanently or they cannot do it infinitely, because right to internet is now a fundamental right. And we appreciate the Supreme Court for giving such a wonderful judgment, which would help in educating the people of the nation, because internet is now a very important source of varied information at a very short time, or in your finger or in your palm. You can just watch in the mobile and get information. So that is how I have discussed on the Constitution of India in a very academic way. Being an academician, so we discussed in academic way of how the beauty of the Constitution of India is, and to make it more beautiful, to make it eternally strong, right? for the integrity of the nation, for the security of the nation, right? For the unity of the nation, whether we need some constitutional amendment or not, right? And in which provision, what amendment has to be made is something which we will decide in the course of time, after discussions, after taking the public opinion, etc., and thus making the Constitution of India beautiful and strong. Thank you so much. Any questions?
Sir, Vivek is asking which one guarantees more judicial independence?
Now, according to the judicial opinion, it is the collegium system that gives them the more judicial independence. That is what the Supreme Court judgment is, the collegium system. So that is their opinion. Now, the government may have a different opinion, the public may have a different opinion, right? For lawyers and for judges and for legal academicians like us, we say that the collegium system is more independent. It gives more power to the judiciary, and that is the system that we are using at present. Therefore, we will stick with that. But there may be some other sections of the society, as for example, the different walks of professions have their different opinions. Maybe the defense sector, maybe the bureaucracy, maybe the medical sector, maybe the accountancy, right? Maybe the acting societies, right? Or maybe even the Kunda societies, right? They may have their own different opinions. But to us, to our legal academicians, I think the prevalent system, the collegium system, is better than any other system. And that's how the NJAC judgment happened. I can also see another question. Anish Joshi. It says that you had mentioned that India has adopted UCC, but as of now, Chhattisgarh is the only state that has adopted it. No, yes, I think you got it wrong. We have not adopted the UCC yet, and that is what I was thinking, and I was saying that for a strong government, right? For a strong governance of the nation, so that by law we bring the nation, the individuals as one, irrespective of any status, irrespective of any status or social status or community, etc., to which you belong, so that with the help of law, you make the nation as one, and therefore the UCC is required. That is what the concern is. Now, why have I said so is because law is a tool of social engineering, right? Law engineers the society. Law reforms the society, right? अच्छा सोसाइटी को भी वो खराब बना देगा, खराब सोसाइटी को भी वो अच्छा बना सकता है, राइट? सोसाइटी जो है वायलेंट है उसको भी शांति ला सकता है, सोसाइटी शांति है लेकिन उसको भी वायलेंट कर सकता है लॉ से, तो वो लॉ से सोसाइटी को सुधार सकता है, सोसाइटी को बना सकता है, इसलिए हम बोलता है लॉ इज अ टूल ऑफ सोशल इंजीनियरिंग. And therefore, UCC is such an initiative which was given right there under the Constitution, so that with the help of law, you bring the diverse society. With the help of law, you bring the diverse backgrounds. You bring the diverse regions of the nations. You bring the diverse communities of the nations into a single law, right? Into a single law. And that is what the Uniform Civil Code means. And in a diverse society like India, right, such kind of law is also required so that it can maintain the uniformity of the people, right? As for example, when you go to a school, you wear the same uniform, right? It doesn't mean that you are from this, you are from that, right? Both A and B, 1 and 2, 4 and 5, C and D wears the same uniform when it goes to a school, right? Because that is the discipline of the school, right? And that is what it meant. That is what the idea of the Uniform Civil Code is, so that we have a single law in India without any confusion, right? That is what the Uniform Civil Code is. Another one, Vivek has asked, what way India should choose, your opinion? Now, I don't get it very well, Vivek. What way, in what sense you are talking it? I think you can retype it. Which way you're talking about? Political way, constitutional way, right? Or when it comes to any other executive, or you can say the media, etc. Which way we should? If you can be a little more specific, that will be great help for me. So I'll keep it for Vivek at the end. Rajender has said, what are the chances of our court for expanding the matter for conclusion rather than adjournment? Right. See, that is a very important question, and which even all the judiciary in India, from the lowest courts to the topmost court, are concerned about the speedy disposal of cases. And that is very important, especially when it comes to civil matters. Sometimes you require it to say like, "Ab ho gaya, court kachara ke chakar ho gaya, ab ho gaya, jo bhi hona hai hone to." Sometimes you come to that extent also when it comes to civil matters. So we need a very special provisions to make it happen in a speedy disposal of cases. But only making laws will not help. Only making laws, only the legislative part will not do. The executive part also has to act on it. So we need a little motivation on the part of the executive part. Plus, what the government has to do is that we need to increase the number of courts. We need to increase the number of judges, right? So that, for example, for population wise, we need to fix some certain number of judges, right? For this much population, 1 judge is required, etc. For this much population, 3 judges required, etc. Right? And that how it should go, because the number of cases that is coming to a judge in the court, it is, I think, humanly impossible to dispose it of within a certain period of time, because we're all human minds and human body. And therefore, to decide a matter, we also require time to study it, to write the judgment, so that it is a good judgment which cannot be challenged, etc. And that's how so many factors are required to for speedy disposal of judgments. Number 1, manpower. That is the judicial officers, the clerks, the infrastructures, etc. Number 2, the dedication, the willingness, or the determination of the men bowering or men functioning on the judicial sectors are all important. Now, there is a lot of improvement in the recent days, but I think we should focus more on the manpower, right? Increasing more judges, number of judges. Okay, Vivek again has asked, it was about NJAC versus Collegium, being an academician. Yeah, that I think I have given the review. I have given my view that since we are legal academicians and we believe in the independence of judiciary, we believe in the separation of power, right? The judgment given by the Supreme Court in the NJAC case is acceptable. It's a good judgment, and that maintains to some extent the independence of judiciary in both appointments and transfers by retaining the supremacy or the of opinion of the CG. Okay, another one, Dinesh has asked, Recently, there are comments from politicians about changing the constitution or making of a new constitution. How do you see it? What's your opinion on it? Is there any need, etc.? Right now, yes, making of a new constitution, I don't think it's possible unless it is a will of the people, because the Parliament of India cannot make a new constitution because the Parliament itself is created by the Constitution. And that is what I have told you in the beginning, that the Indian Constitution is so beautiful and it is eternal, it is immortal, right? Because the Parliament of India is created by the Constitution. And therefore, the Parliament cannot kill the Constitution, they can only amend. But even on the amending powers, the Supreme Court has laid some restrictions by bringing in the basic structure doctrine, and therefore we see that the power of the Parliament has been curtailed not only by the Constitution itself, but even by the judiciary. And therefore, making of a new constitution is very difficult unless the present constitution is killed, the present parliament is killed, right? It's done away, and a new constitution is made with a new nation, right? With a new nation. So that means it is only possible only when there is a new nation. But constitutional experts have said that the Constitution of India, present Constitution of India, is immortal because of its amending flexibility. And therefore, new constitution is not required. You can amend the constitution according to the needs of the society, and the present constitution can be carried on immortal. Now, next question is Swarya, is if any political parties come to power, can the basic structure be changed? See, the Swarya, the basic structure is a judicial theory, and unless the judiciary, by its judicial review again, declares the basic structure doctrine laid in Keshavanand is invalid and it is overruled, I don't think so that we can have a system where we will do away the basic structure doctrine, because in the present Constitution of India, the judgment of the Supreme Court is final and it is binding on all the citizens and all the machineries and constitutional bodies of India. Yes, any more questions?
Yes, Prathamesh.